Appears defense that your main concern is that you don't want them to seek to establish that maybe your client was intoxicated.
Correct, Judge.
You're going to try to say that he was intoxicated at the time?
No, Judge, because he's not charged with intoxication manslaughter. He's charged with manslaughter. It's just the fact that he was consuming alcohol and whether or not it could have played a factor in what happened.
All right. So we're going to go on the record, 2022 CR 11862. State of Texas versus Alexander Joseph Castro. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Sorry, Judge. Gary Hillier for Mr. Castro.
And are you Mr. Castro?
I am Mr. Castro.
All right. So let's first take up defense's motion in limine because I believe that will be a quick one to take up. State, have you had a chance to review the motion in limine?
Yes, Judge.
All right. And state, do you have any objections?
Yes, Judge, to section 1 and to section 2. Both of them talk about impaired and the defendant consuming alcohol. In our indictment, one of the manner means is through the introduction of alcohol. We're not alleging intoxication, but that is one of the manner means that we were trying to go with recklessness. And so the state feels that if we have to be limited in whether or not we can question that the defense has been on notice, well, that would limit us in the presentation of our case.
All right, just one moment. Let me pull the indictment.
For a second, thanks.
All right, so state, my understanding then is you're not trying to say that the defendant was intoxicated?
No, Judge, it's just that one of the ways that he was reckless was that before driving his vehicle was that he was consuming alcohol, that he admitted to consuming alcohol.
All right. And it is in the indictment, counsel. So what is your argument to their argument?
So the first part, Judge, part 1 is our objection to we anticipate the state is going to try to bring evidence that Mr. Castro was intoxicated. So the first bit is intoxication, Judge.
All right, so let's stop there.
Number 1 is intoxication.
All right. So are you going to try to say that he was intoxicated at the time?
No, Judge, because he's not charged with intoxication manslaughter. He's charged with manslaughter. It's just the fact that he was consuming alcohol and whether or not it could have played a factor in what happened.
All right. So defense and state, then with regards to the motion in limine, if you are going to seek to establish that he was intoxicated, y'all need to approach before that's done. But if the only issue is going to be that he consumed alcohol before driving, then the court is going to allow that. And it appears, defense, that your main concern is that you don't want them to seek to establish that maybe your client was intoxicated.
Correct, Judge. That's the first part.
All right.
Judge, can I
Yes, you may continue.
So, Judge, the second paragraph is obviously, and of course we object to it in the indictment, but we understand it's part of the manner and means that the state is going to try and establish. One of the standards that the state we anticipate is going to try and prove is that Mr. Castro was impaired through the introduction of alcohol into his body. Now, the problem with that, Judge, it's confusing. It hits almost everything in 403. It's an improper legal standard. It's not defined in the code. It's not defined in case law. So we would be asking the jury to make a factual determination based on a made up or non-legal term. So it's confusing and it would ask for speculation. The consumption we understand is a court's ruling, Judge. That's fine. But this impaired word is not a legal word. And so we object to any evidence about impairment.
All right. So what happens in courts where there are not legal definitions for words? Do we not use them because there's no legal definition?
I think that that's the way that courts that it's defined through case law, Judge, and it's normal usage. But the reason that we object to the word impaired is because impaired is kind of synonymous with intoxicated for a layperson. We know as attorneys that according to the code and law, case law, intoxication is very well defined, and it's clear. It's under 4904 of the penal code, but impairment's not. And so impairment in a juror's mind, despite the court's instructions and explanation, could still be the equivalent of, oh, he was intoxicated then. So it's the same thing. It's like saying, using the word drunk.
But isn't that something to handle through cross-examination?
Well, that might be how the court rules, Judge, and we'll, but that's our argument, Your Honor, and we'll leave it to the court to rule.
All right, defense. I'm sorry, state.
And Judge, again, we disagree. Again, the jury would be able to, just because it's not legally defined, they can use the normal meaning of the word. Again, that's something that it's through defense and statements and just the circumstances around what happened. That's at least something that they can make a determination. And again, we're not trying to say intoxication, but again, it's impaired. That's something that, again, that word may not come up.
All right. So with regards to the balancing test on whether or not that line of questioning should be allowed, I'll need to make that determination at the time evidence is presented. So, state, before you have a witness testify that you believe or they believe that Mr. Castro was impaired, we'll just have the jury step out for a moment so I can hear the question and make a ruling with regards to 443. I'm sorry, 403. All right. So our number one, I believe that's been settled. So you can ask questions in regards to whether or not alcohol was consumed. Number two, you'll need to approach.
And Judge, just for the record, so number one was more intoxication, number two was impairment, and number three, I apologize, that was consumption.
All right. So, well, number one, that's been granted. You're not going to try to establish that he was intoxicated. Is that correct?
Yes.
All right. So if something changes in regards to number one, then you all have to approach and we'll handle that outside the presence of the jury. But number one, that will be granted. Number two, you'll need to approach. And number three, defense.
Again, I think I know the court's ruling. Again, it's a 403 argument. We'd ask the court to make a balancing determination to see whether any evidence is the risk of confusing the jury, the issues, misleading the jury, substantially outweighs any probative value at the time.
All right. Well, number three appears to be that you're not wanting the state to mention that Mr. Castro had allegedly consumed alcohol.
Correct, Judge.
All right. Well, that's in the indictment that they're stating that he consumed alcohol. I will, you want a 403 balancing test. Here's the thing. I can't do a balancing test until I hear the evidence, but I will make my ruling when I hear the evidence. But defense, what I'm telling you is the consumption of alcohol is in the indictment. And the state, in their argument, said that your client admitted to consuming alcohol. Whether his admission that the state is alleged he did comes in or not, that's another question. But I really don't see at this point in time how that would be prejudicial.
Again, if I may supplement that, Judge, I'm sorry, I should have said it before. Case law has established that consumption of alcohol is not illegal. And so to allege that as that consumption of alcohol is a manner of means on its own that is equivalent to recklessness is misleading in itself. And that's my argument, Judge, and we respect the court's ruling.
Okay. All right. So with regards to the consumption of alcohol, state when you are ready to ask a witness whether or not Mr. Castro admitted to consuming alcohol or however you wish to have the evidence presented that alcohol was alleged to be consumed by Mr. Castro, just approach. And for that part, I'll have you all come forward and I'll do a balancing test.
Yes, ma'am.
All right. So far, does everyone understand the court's rulings? All right, then let's move on to number 4, prior convictions.
Judge, the state's in agreement. The only caveat would be is that if the defendant does take the stand, if there's anything that comes up
All right, so with regards to prior convictions, if anyone believes that they should be allowed to ask questions about that, just approach before you do so. Extraneous offenses?
Same thing, Judge, if there's any sort of opening the door like that, the defendant will take his hand.
All right, just approach beforehand. All right, defense, do you have, I know you have the time motion that you wanted to talk about, but before we get to that, any other motions other than that?
That's all, well, for now, Judge, that's all we needed to be ruled upon before we pick a jury. That's it for now from the defence. Thank you,
All
Judge.
right, so then we're going to move on with the state's motion, and they want to have the jury view evidence outside the courtroom. Defense, have you had a chance to review the state's motion?
I have, Your Honour.
All right, defense, are you in objection?
I do object, Judge. Yes, we do.
All right, I'll hear your objections.
Your Honour, and I've got two cases for you.
Okay.
And I'll give the state the, it's Andika versus state. And one of the cases is one.
Just one moment. For the court reporter, it's Andika, Andika, the state. All right. Yes.
So thank you, Judge. So we do, we've seen the state's motion and we object. And based on the case that the state cites in its motion, which is Mauricio versus state, and I can give you a citation if you need it.
Yes. And here's the thing, everyone, when you all are saying cases, because we read case law all the time, court reporter doesn't read case law all the time. So if you all could pronounce it and make sure that you, if you want your record to be clear, make sure that you spell the case to the court reporter and whatever site you have.
And it's Mauricio versus state, Your Honour, and it's the citation is 153 Southwest 3rd, 389. And this is the state's own case that they cite. And basically our objection, Your Honour, is that what the state is proposing is an improper demonstration or representation, or some misrepresentation of the scene as it happened on the evening. Now, I don't know what the state is trying to prove by bringing these vehicles here. It's certainly overly prejudicial. It will be misrepresenting the state as it appeared on that day, because obviously you can't recreate, obviously the court doesn't know this, 281 North in the space between the two vehicles where the accident crash site was over a quarter of a mile at least. There'll be a misrepresentation of the crash. And it goes to what the court says in Andika, in the case you've got there, Judge, and I highlighted it, that the court, one of the things that the court can consider is the nature or the deterioration of the scene or the items to be viewed. Now, my understanding, these vehicles have been kept in, what's it called? At the pound, SAPD pound, and they've been there for 2 years. So the condition that they are in today is not the condition that they were in 2 years ago. They've been outside, it's grounded, and they're outside. So they would have been exposed to the elements. So they will not look today like they did 3 years ago. And the case that the court, that the state cites, Mauricio, in that case, that was a demonstration. Mauricio was a demonstration where, and this case isn't Mauricio, this is a case where there was an accident. And we're just going to be looking at the vehicles. Now, what the case law says is, one of the things that the court consider, Your Honour, is that whether that evidence can be obtained from more traditional means, such as photographs and videos, which there are in that big box over there are hundreds of them.
Okay, so let me just stop you a little bit because I like to take things one step at a time. So it appears your first argument is that the state may be seeking to recreate the scene on 281, potentially.
Possibly, that's correct, Judge.
State, are you trying to recreate the scene from 281?
Judge, the reason why we gave notice to both the court and to defense is that you could make a determination as to how we present the evidence. If you say that we need to try and recreate it as best, we can try that. If it's just we bring the cars here and we show them, that's up to the court's determination.
But no, my question is, are you seeking to recreate the scene from 281?
No, Judge, because as defense counsel mentioned, that is a very large stretch of highway. What we would do is trying to just present the car so that they could see the condition that they were in.
All right. So then you're saying that you want to just present the cars so that the jury can see the conditions the cars were in.
Yes, Judge.
All right. So then his next argument, and correct me if I'm wrong, he's saying that because the cars have been at the pound in the element, and I don't know if they've been in the element or if they were covered or not, but he's saying cars have been at the pound for over 2 years in the elements. Are those cars in the condition they were in at the time of the alleged crash?
My understanding, Judge, is that they've been left grouted in that no one has gone in and done anything to the cars.
But have the elements changed?
My understanding, Judge, is that they've been covered in plastic and that they have been covered.
All right. So the first thing that the court will need to know, and there will need to be witnesses, I'm assuming, for this to say that the cars were protected from the elements.
Yes, Judge.
Because I can understand if the cars were not protected from the element. I'm not a vehicle expert, but I know a little thing about vehicles. If you leave them in the elements, what will happen? Rain, hail, whatever. So I will need to hear from someone. And I don't know if defense is aware if the vehicles have been covered, if they have been protected from the elements. So I would need to know that in order to make a ruling based upon the objections you have. So the state is saying they are not trying to recreate the scene, but they want the jurors to see the state the cars were in after the alleged crash. Then the next question, based upon his argument, is there some other way to do this other than viewing the cars in person?
Judge, even looking at the photos, just due to perspective, it does create issues with recreating the scene itself. So that would be one difficulty. That's why bringing the cars themselves would be important. Because,
But you said you're not recreating the scene.
or just to bring the cars back to show the condition, Judge. Sorry about that.
Okay.
To where, again, just the perspective, the size, damage, things of that nature, it'd be difficult to recreate that with just photographs and with the video, any video alone.
Okay. All right. So defense, they're stating that it will be difficult just through photographs to show the size, which I think we all know that photographs are not, you're not going to show if a car is, 20 feet or whatever, you're not going to bring a photograph that's 20 feet. So they're saying that the photograph will not, I guess, show it as accurately as an in-person viewing of the vehicle. I think that's their argument.
And Judge, with respect, it's not the court. I disagree with that, obviously, because.
Oh, no, I'm just stating.
I know,
what they're
no,
saying.
Judge, not
Yes.
yourself, but I with respect to the opposing counsel, I disagree with that. It's standard in any of these cases where people know how big a car is and how big a truck is, Judge. They know that from common experience. Is there anything to be gained from seeing the actual object itself? I mean, and it's almost, it's like where does this end argument? Because if we're going to do that, then it's still an improper reconstruction. Judge, it's cumulative to as well. I mean, it's a cumulative showing of evidence that Mr. Escobar yesterday, I don't know if that's their plan. I don't know what the state's plan is for this case, said he was going to try and do that on Friday. Well, I'm assuming that's towards the end of their case after they will have submitted photographs. So to do that would be cumulative and it would be overly prejudicial because, and again, and I mean, cast no aspersions on the state, and I mean no offence by this, it would be done for the shock value to see the actual vehicles themselves because they're in a terrible state. And that evidence can be put into the record fairly through videos or photographs, which is the norm under the Texas Rules of Evidence, Judge.
All right. And I understand when people say that things can be put in videos or things can be done a certain way, but I'm a firm believer that people should be allowed to present their case however they want to present it. So I do have some questions. So you would be able to have the vehicles brought down
Yes, Judge.
and those arrangements could be made.
Yes, Judge.
And where would the vehicles be placed if they were brought down?
In between the two courthouses, Judge, we've reached out already to SAPD to start to give them a heads up that we're going to be asking that they be brought down. And just a time schedule, really, it's just at this point when the court would allow us to do that so that we can just give them a firm time, give them a firm schedule.
Oh,
Judge,
yes.
sorry. Jason Garahan for the record, Your Honor, for the state. I think my suggestion would be is if, we can bring them down no matter what, so you can inspect them if you like, the defense counsel will inspect them before we, show them to the jury. And that way you can see from photos that, defense counsel has, whether they elements have attached to them or anything has happened. I think that would be the most fair assessment there, Judge. And, the state, this is pretty standard throughout the state of Texas that cars are brought in for these type of cases because it shows the amount of damage, the amount of power, the amount of speed that happened during the case. And no photo can give any type of perspective to a juror about the amount of damage. It's just like taking a bed into a courtroom where somebody was stabbed to death. It's brought in because it shows the amount of power, the amount of damage that could possibly happen.
All right. And what I can tell both parties is I'm going to hear your argument. And I was going to suggest that the vehicles be brought down because that will enable me to make a fair ruling. So everybody is, I know you're speaking what the photographs show, but I'll need to see the vehicles as well to make a ruling. Okay. But I want to make sure I have everybody's arguments clear, and then I will make my ruling once I see the vehicles. All right. So the other thing is, so what information state are you hoping to gain, Mr. Garahan? I know you mentioned some things you hope to gain from having the vehicles brought down that you're not able to gain through photographs or videos, but if you could just elaborate on that, please.
Yes, Your Honor. Discussion with Mr. Escobar on this case. The actual physical evidence is brought in all the time during cases. A gun, so to say. And I know defense probably objects to a lot of guns coming in, but the fact is, this is very similar to that. It's one in this indictment. It says deadly weapon. One thing that we have to prove that the individual used his truck as a deadly weapon. Hence, we're bringing it in, just like we would bring in a weapon of a handgun or a rifle type caliber. So actually perspective and seeing that in the physical form, one, it shows the power, the amount of energy that was used. One thing that we've alleged excessive speed, that would also be something that the jury can view, and that can only be obtained most of the time from actually seeing it in the physical form.
Anything you wish to add, Mr. Escobar?
No, Judge, I think that was very good summary of what my argument was about to be.
All right. And then counsel, with regards to your argument, the change in appearance, of course, I won't be able to see the change in appearance until we have the photos for me to see and for you to see the photos as it relates to the vehicle. And then, of course, I'll give you both the chance. If you have more arguments, once you see the photo in the vehicle, you can place that on the record as well.
May I very briefly respond to the state's argument there,
Yes.
Your Honour, because from Mr. Garahan, and with respect, again, this is what we're talking is a crossover into expert testimony. By looking at an object, a jury of lay people can't tell the power and speed of vehicles. They can make conclusions and assumptions, but Mr. Castro shouldn't be convicted based on assumptions alone and conclusions by lay people. Normally the predicate for speed and power is laid by expert witnesses, not by viewing an object. And so we object to that. It's cumulative and it's overly prejudicial, but it's in the discretion of the court and we respect the court's decisions.
All right, we will see, and we will see whether or not there's just a viewing of the object if the court were to rule that the objects were allowed, and whether or not testimony is taken between the Sally Port outside or not. That's something you may want to speak on if it gets to the point where testimony needs to be taken outside. And the reason why I bring that up is based upon the argument that you've just given the court about an expert.
And Judge, and to that point, Judge, in the case that the state cites gives a good roadmap of, the court having to set this up with a court requiring your point, Judge. A court reporter needs to be there in case there are comments made by anybody.
Oh, the court reporter will be there.
Yeah, and just be set up in a way. And again, but we respect the court's decision.
All right. So I've heard both arguments. Is there any? It's you're objecting. It's their motion. Do you have anything else to add?
Nothing else to that, Your Honor. Thank
All
you.
right, state anything else to add because it's your motion.
No, Your Honor.
All right, then what we'll do is, once the cars are brought, and I think it would probably be best to time the bringing, we can go off the record. I think it would probably be best timing to bring the vehicles is when we're close to any testimony or anything about the vehicles, because I don't want them sitting between the two buildings for any length of time.
And to that point, Judge, I guess they're going to need to have people, SAPD or officers guarding them. Not guarding them, but babysit.
I understand. Yes,
We were taking precautions on that.
yes.
Because they're not going to be admitted, obviously, right? They're demonstrative evidence, I'm assuming.
Yes. Well, I don't think the court reporter wants to take.
Well, you know,
And her room will not be able to hold vehicles.
well, I don't know what the state's intention is, Judge. No, I'm like,
All right. So, then you say a timing issue, counsel?
I do, Judge, and I'm sorry, Judge, but in the abundance of caution, Your Honor, I know that you will remember, Your Honor, we were here 10 days ago on.
I'm sorry, I don't know.
No, we're not on the record. Just go
Oh,
ahead.
no,
Timmy.
so,
Yeah.
okay, Judge, we had a motion on our motion for continuance 2 weeks ago because I was at the CLE.
Yes.
And I've got a copy of the motion here, Judge, for your,
Mm-hmm.
and I know you'll remember, Your Honor, I going on vacation on Saturday of this week for 2 weeks, and the
Oh,
court,
this trial is going to be finished.
Judge, with the greatest respect, this case is that whole box thing. Even
Oh,
if we
no,
don't
this-
ask the question.
Here's the thing. You all are wordsmiths. I know people are not going to be asking questions that do not need to be asked. I'm pretty sure there's not going to be a recross and a redirect. We've had trials in this court. And I judged length of time. Is there a video that's 13 hours?
There is excessive body cam.
But is it like over 13
You're
hours?
not playing proportions.
All right.
It is, there's three body cams that are at least 6 hours long. And then there's one body cam that's 3 hours long.
Well, let me just tell you, my salary is paid by the taxpayers. And guess what? If we need to be here on Saturday, I know nobody has anything to do. I will be here on Saturday. So we're going to get it done.
Judge, if I may, I'm actually, I've got a vacation notice on file. I have non-refundable tickets leaving on Saturday.
Oh, where are you headed?
I'm going to Florida. I'm going on a cruise in Florida.
Let me just tell you, you know what? I've heard so many bad things about cruises.
I don't
I
want to
may
go,
be
Judge.
I may be saving your life.
My wife's making me go, Judge, and she'll
Oh.
kill me.
Your wife is making
She
you
is
go.
making me. I'll do that for the record.
Oh, I can't even believe you would say, let's put that on the record. He
put
says
it on
his
the
wife
record.
was making him
I'll
go.
put it on the record. She won't.
No, let me just tell you, this is going to be done. And you know what? If we believe it will be done, it will be done. But if we don't, then we're just putting negative things out in the universe. It will be done.
If I
You
may,
will get on your cruise. What time is your plane?
8 a.m. on
8
Saturday.
a.m. Oh, you'll make it.
Your Honor, we are going to the jury for punishment.
You'll make it.
That is, I understand what the court's saying, Judge. I'm the only one who knows really anything about this case.
You'll make it.
I don't want to bake into the case any ineffective claim. I
You'll
don't-
make it.
With the greatest respect to the court had suggested originally trying it on the 19th.
No, you'll make it.
And again, I understand what the court's saying, but I just want to put it down for the record.
Oh, let's go on the record.
Oh, yeah, we're not on the record. I'm sorry, Judge.
No, because I was hearing what your vacation plans was. So, your defense, you say that you have a vacation letter on file?
I do, Judge. It's in the motion that we considered before.
All right. We will make sure that you make your,
Are there right notes
vacation.
on the back of that, Judge? I might have.
No notes. All right. So, we're going to start jury trial today. We're going to go all day on Wednesday.
Yes, Judge.
We're going to hopefully finish this trial before Saturday. All right.
Yes, John.
Is there anything else?
Nothing from the state.
May I
Anything else?
briefly put some on the record, Your Honor, in
Of
that
course.
case? Then I respect the court's decision, but this is for the record, for my client's benefit and for the future, because this, I'm interested in finality of this as much as the state is and the court is. And it's about fairness to the state and the parties. And I'm concerned that I have a vacation letter on file and I leave out of town on Saturday morning. And I'm concerned that we will not finish this case by Friday. We have elected, or we're electing to go to the jury for punishment, Your Honor, which means getting through the state's case in chief. And they've already indicated that they're not going to bring these vehicles for this jury view until Friday.
Oh, they may end up bringing them sooner.
They may, Judge, and they may, Your Honor, but that was what they indicated yesterday.
I discovered sometimes when people think trials will last long, I've had people tell me, oh, this trial is going for 2 weeks. And then they're like, oh, we finished earlier than we thought, and it's in 2 days.
It could happen, Your Honor. When we appeared last time, and I checked last night on the YouTube feed, that we mentioned, the state said it would be 3 or 4 days, and I've said from the beginning, it's going to be a 5-day trial. Your Honor, I don't know how many witnesses the state are calling or who they don't call, so we may have to present the case. And so then we're asking for the case to be finished by Friday, the jury to be charged and argued, and possibly a verdict with a punishment trial to follow. I'm concerned that it will be ineffective of me if I am trying to concentrate or miss something because I'm worried about trying to rush this case through to its natural end when we could just reset it to the
I
19th.
say concentrate on this trial because that's where we will be. All right?
I understand, Judge.
All right. So motion for continuance is denied. Anything else from either side?
No, Judge.
All right. So a jury is going to be called up. We're going to pick a jury this afternoon. And then everyone needs to be here tomorrow at 9 a.m. And we're going to start testimony at 9 a.m. Everybody needs to be ready to go at 9 a.m. 9 a.m. Nobody running in. You know, it's like a plant job. You need to be at your desk and ready to go at 9 a.m. No, we're setting up. Be on the assembly line. Even though you're getting paid at 9 a.m., I will tell you, my mother would always say, her employer would say, you're late if you're not here early. So 9 a.m., all the computers ready, everybody's ready to go. All right. And we're going to come back this afternoon at 1:30 and we're going to start jury selection.
Yes, Judge.
And Your Honor, on that, how long can we have an hour for jury selection each side?
I mean, this is a simple case, is it not?
Nope.
All right, I'll give everybody 30 minutes. Is there anything else?
Judge, can we ask for 45 minutes? It's not a simple case. There are intoxication suggestions, there's causation issues, and the state will probably agree there are issues with the investigation. There are, Judge. We'd ask for 45 minutes.
35 minutes.
Thank you.
Thank you. And counsel, if your client were convicted, it's jury for punishment. Have you filled out the election?
Just do it now, Judge.
Okay.
And he's probation eligible as well, Judge.
Yes,
We're filling out
okay.
the app right now.
And we're looking at probation or 2 to 20, correct?
Correct, Judge.
All right. Thank
Thank you,
you.
Judge.
Thank you.
What started as a debate over legal definitions quickly became a powerful reminder that courtroom decisions often shape a trial long before the jury hears the first witness. Judge Boyd carefully balanced both sides, refusing to let emotion replace evidence while making it clear that every ruling had to protect the fairness of the process. Whether it was arguments over alcohol evidence, damaged vehicles, or trial scheduling, the message stayed the same. Every decision matters when someone's future is on the line. Do you think Judge Boyd made the right calls throughout this hearing, or would you have ruled differently? Share your thoughts in the comments below.
And counsel, if your client were convicted, it's jury for punishment. Have you filled out the election? Okay.
He's probation eligible as well, Judge.
Yes,
We're filling out the
okay.
app right now.
And we're looking at probation or 2 to 20, correct?
Correct, Judge.